Welcome to the Fiancée video tutorial. Really glad you're here with me. We're going to have some fun going through the entire process of preparing, filing, and going to the embassy for a fiancé visa. So settle in. We're going to take some time to do this, and it's going to be really great and have a lot of fun doing it. And I'm going to do this real time. So we're going to work together. You're going to see how I approach putting together fiancé visa packages and doing the research and checking on the forms and doing all the document prep. Because what's important to know is that all these rules are changing all the time. The embassies can change, the USCIS forms can change. So what I want to show you then is really how to do this research on your own. And we're going to start by giving you an overview of the fiancé visa process. So I prepared this little diagram here, and this is a really general overview, obviously, but it's going to help you to understand when we go into the minutia of this process exactly what's happening. So the first agency to review the fiancé visa here is the USCIS. USCIS is the United States Citizenship and Immigration Service. And you file the form I-129F with them, and you file the G-325A with them, and that tells them basically that the fiancé relationship is real. And what their whole point is they want you to prove to them that the fiancé relationship is real. And so for that reason, we like to put in all the proof, the photos, and as much information as we can to show that it is a real fiancé visa. And so when that's done, then we're going to go over here, and it's going to get approved, and it's going to get transferred over to this other agency, which is under the Department of State, and that's the NVC, the National Visa Center, and the U.S. Embassy in the country where your fiancé lives. So these guys, then, they have a bit of a different emphasis on what they're doing, all right? To them, you need to prove that the fiancé is not a threat to the U.S. So that's at this level, that's when they're doing the police reports, that's when they're doing the medical exams, that's when they're doing all the background checks to make sure they're not a terrorist or money launderer or a drug dealer or any of these bad things, which will actually keep them from coming to the U.S. because under the embassy there, that's a threat to the U.S. We're not going to let those people in, right? So this is the basic idea. We're going to start here with doing our petition with the USCIS, and that's a petition is what the USCIS is going to be, deciding, and that's where a U.S. citizen actually requests, hey, this is my fiancée. I want to I want the possibility of her coming in with a visa, and so. And the National Visa Center, Department of State, a totally different government agency, is going to determine whether or not they are cool to come in. So then let's start with Google, with the research, okay? So we're always going to look at websites to get the most relevant and up-to-date information. And so the first website we're going to go to then is the USCIS. There it is, USCIS homepage. Okay. Now I'm going to be resizing these things down, and because of my screen capture, it makes it kind of tricky sometimes with getting these websites to look good for you guys. So here we are. This is the USCIS website as of today, which is January 18th, 2012, right? Now, you might be viewing this thing February, March, April, May, 2012, 13, 14, who knows, okay? So that's why you need to be going back, because they may have a whole new set of forms, they may have a whole new set of requirements around it. And whatever happens, you're going to be able to figure out what's going on if you're looking at this website. So this is where we go to view the forms, and we're going to go way more deeply into form preparation. I just want to give you the the broad brushstrokes right now. And the form that we're looking at is an I-129F, so we can just scroll down here. There it is, petition for alien fiancé, right? And this page here there's the form, here's the instructions. This is a really great thing, notification of acceptance of application or petition. You know, and that's a great way to get it over a text or an email. You can sign up for that service. And then we have other things here. We have some informational pages. Here's one on fiancé visas, right? And so this was going to give you the overview of what's actually happening with fiancés. So let's look at this a little closer then, because I want to get into this. This page provides information for U.S. citizens wishing to become a foreign national, wishing to bring a foreign national fiancé living abroad to the United States to marry. So a couple of key issues here. U.S. citizen, right? Okay, U.S. citizen, only U.S. citizens can apply for fiancé visas, all right? A foreign national fiancé living abroad, right? So we're envisioning someone actually living outside of the United States to the United States to marry. So the purpose of this visa is actually come here to get married. So some visas you come to be a student, some visas you come to be an investor. This one you come to get married. Very clear, specific intention around that. Okay. Application process, there's the I-129F, petition for alien fiancé, and of course we're going to be going through that step by step and line by line. Eligibility requirements, okay? If you petition for a fiancé visa, you must show that you, the petitioner, are a U.S. citizen. That's right. So how do you do that? Birth certificate, naturalization certificate, something like that. You intend to marry within 90 days of your fiancé entering the United States. So if you're already married, you can't really prove that you're going to be marrying again in 90 days because you already have one spouse, and you can't have two spouses here in the United States. So you got to intend to marry. You and your fiancé are both free to marry, and any previous marriage must have been legally terminated by divorce, death, or annulment. Okay, so the legal termination. This is a whole document thing around making sure the divorces are okay and that they're properly executed in front of a judge, and that that paperwork looks good. Here's another one here. You met each other in person at least once within 2 years of filing your petition. Okay, so meeting once within 2 years. Pretty easy to prove that. Most of the fiancés actually that I run in actually have that, except there are some exceptions. One, if the requirement to meet would violate strict and long-established customs of you or your fiancé's foreign culture or social practice, right? So there are some practices that are definitely prohibit that. So if you can prove that, you're okay. And then two, if you prove that the requirement to meet would result in extreme hardship to you. So this extreme hardship then is a thing where if you're incapacitated, you can't travel, your parents have set this thing up, and you've Skyped a lot, and I can't fly over there to actually meet her, but everyone knows we are meant for one another, they will give an exemption then from the requirement that you have met her. Okay, after the fiancé visa is issued. Once issued, the fiancé visa or K-1 non-immigrant visa, that's true. K-1 non-immigrant visa is another word for fiancé visa. Allows your fiancé to enter the United States for 90 days so that your marriage ceremony can take place. Once you marry, your spouse may apply for permanent residence and remain in the United States while USCIS processes the application. Great. For additional information, see the green card link to the right. So this is an interesting thing because, you know, what if the marriage ceremony doesn't take place in 90 days? What happens? Well, I'm going to cut to the chase here and just tell you that if you are not able to get married within 90 days, you can still file for a visa petition, right? If as a U.S. citizen, can still file a visa petition for my spouse if we get married on the 91st day, right? What happens though is I can't use the approved fiancé visa as a support for the green card application. I have to file a new I-130 petition a marriage-based visa petition for the basis of that green card. So if you don't get married in 90 days for some reason, you get 91, 95, 105, okay, you can still go forward and get that fiancé a green card, right? But it's a different petition. You have to start over with a new petition. You're married now, so it's going to be marriage to a U.S. citizen. You're proving they entered legally on a fiancé visa. So it works okay. I've done that before. Okay, treatment of I-129F petitions where the Department of State refuses to issue the K-1 visa and returns the expired petitions to USCIS. There's an interesting issue. Once USCIS receives a consular returned I-129F for K-1 classification from Department of State and the petition is expired in accordance with 8 CFR 214.2K5, USCIS will allow the petition to remain expired and will not reaffirm or reopen the petition. Therefore, the petition will expire in normal course. Please note this will not preclude the petitioner from filing another petition. Basically, what this means is that if you go through the embassy process and at the embassy they determine this is not a real fiancé, this is fake documents, all kinds of different stuff that can pop up and disqualify someone from being a fiancé, they're going to send the petition, which has already been approved by the USCIS in that first step, back to the USCIS with information saying, no go, cancel out, this is not good. And so USCIS is going to kill that petition right there and not allow you to appeal that decision or do anything around that. So that's what that means. And yes, you can file a new one because sometimes it's just a lack of proof that you didn't get your stuff together in time, and you show up to the interview and they're mad and they want to disqualify you for that. Children of fiancés. If your fiancé has a child under 21 and unmarried, a K-2 non-immigrant visa may be available to him or her. Be sure to include the names of your fiancé children on your Form I-129F petition. So there you go. You can definitely bring fiancé children over, and they have a separate category of a K-2 for them. Permission to work. Now look at this. After admission, your fiancé may immediately apply for permission to work by filing a Form I-765, application for employment authorization with the USCIS Service Center having jurisdiction over your place of residence. Any work authorization based on a non-immigrant fiancé visa would be valid for only 90 days after entry. However, your fiancé would also be eligible to apply for an extended work authorization at the same time as he or she files for permanent residence. In this case, your fiancé would file Form I-765 together with Form I-485 as soon as you marry. So it is true, the fiancé visa category does provide for a work authorization card to be issued to that fiancé when they enter the United States. That's definitely true. It's only good for 90 days, okay? How long does it take for a work authorization card to be issued? 90 days. I mean, so once you apply for it, you know, it's pretty much expired, right? So it's very rare that we have people apply for work authorization cards based on fiancé visas. What normally happens is they come into the United States and they're going to apply for, they're going to get married and then they're going to apply for the green card, permanent residency based on the marriage. And then they're going to go ahead and apply for the I-765 and they're going to get their work authorization card that way. They wait the 90 days and then they get the work authorization card. So, but it certainly is possible to do that, and if you're an eager beaver and you really want to get that work authorization going, file it, you know. What happens if we do not marry within 90 days? Fiancé status automatically expires after 90 days. It cannot be extended. Your fiancé should leave the United States at the end of the 90 days if you do not marry. If your fiancé does not depart, he or she will be in violation of U.S. immigration laws. This may result in removal, quote-unquote deportation, and or could affect future eligibility for U.S. immigration benefits. Okay, so this is true. It is true that if you do not marry within 90 days, the fiancé visa is over and you should leave. Especially if fiancé relationship is falling apart. Because with fiancé visas, once that 90 days passes, there's no way to change status or go into any other category except for a marriage to your sponsor. So like I say, if there's a delay in the wedding and you don't get married in 90 days and you finally get married and it's to the same person who petitioned you, then you're picking up and you're moving forward in that same path. USCIS is not going to have a problem with that, okay? The problem is you come on a fiancé visa with one guy, and then you get rid of him and then go marry someone else and try to get a green card that way. Oh no, that's definitely not going to work. And even if you don't get married in the 90 days and you're still wanting to get married to the same guy who petitioned you, you're deportable. So if on the 91st day you haven't gotten married and you get pulled over and it's one of these 287G, I guess they're not doing that anymore with Obama, but if an ICE agent picks you up and checks you out, 91 days, you are deportable for that. So it is true that you would be deportable. So that's a really good distinction around the what happens if you don't get married. We want to make plans for a wedding. How long will this process take? Each case is different. Please check the current processing times for the I-129F petition. See the check processing times link to the right. We process fiancé petitions in the order we receive them. Once we complete our processing, your approved petition is then forwarded to the National Visa Center. Yeah, that National Visa Center will then send the petition to the U.S. Embassy or consulate, which will need time to process your fiancé for a visa. That's true. Right now, it's taken around 9 months to a year in our experience to do a fiancé visa, right? And it is really true that check processing times. This is a really great thing here. You can go on and pretty much figure out like what is going on with processing time. And when we take on a case and we're doing a fiancé visa, we always go to this window and look at the processing time at the beginning, because all of our clients are always asking us the same question: how long will it take? How long will it take? And we just basically say 9 months to a year between the time we file this petition until they actually cross into the United States. And that gives us the flexibility to make it through all of these agencies. But the first thing, the USCIS processing time, really will give you some idea of what's going on right now. And so here we have it. We've got the there's the field office. Let me get this thing straightened out a little here before. There we go. Service Center or National Benefit Center. So we know, I think it's the Service Center is the California Service Center that actually does the fiancé processing. So, but they change them all the time. So we would start with this processing center and go to the I-129F. Here we go. I-129F. See that? Petition for alien fiancé. K-1, K-2, not yet married. Fiancé and or dependent child, 5 months. So what we know then is that when we file the I-129F, we're not going to follow up until 5 months. No point. They're not going to, there's no need and no purpose in following up with USCIS before 5 months. So that's how we gauge our first follow-up time right there, is by doing that. So, so this is our overview then of the fiancé visa from the perspective of the USCIS, okay? So what I want to do now then is I want to look at the embassy stuff, because this is where stuff gets really, really good. So we're going to go to National Visa Center, right? National Visa Center. And what pops up is this website, travel.state.gov. This is the gold mine. There is so much information here on travel.state.gov. And for our overview of fiancé visa processing, we're going to get into the nitty-gritty here. All right. So we're here and we're under visas. And when we're going into visas, right, you can see there's already a bunch of information here. We scroll down, and it talks about how does the National Visa Center fit into the U.S. immigration process. Okay, that's a pretty big picture. USCIS sent my immigrant visa petition to the NVC. Now what happens? Okay, that's big picture. How do I know my priority date meets the most recent qualifying date? What does that mean? With fiancé visas, the priority date issue is really moot. How do I know what my priority date is? Moot. There's a lot of stuff here, right? You're getting on this. What am I going to do? Well, I am going to go to immigrants to the United States, right? And then we're going to go to immigrant visa processing. And in the immigrant visa processing, even though the fiancé visa is actually a non-immigrant visa, right? It's treated like a immigrant visa in that they are going to require a lot of medical exams, and they're going to require a bunch of different information that just coming over as a tourist, a regular non-immigrant visa. They don't require that information of them. So fiancé visa is a bit interesting because it does have both characteristics of an immigrant visa and a non-immigrant visa. All right. So look, I don't see this stuff. But where's my fiancé visa? I just want to get fiancé. I don't see anything over here, right? So I'm gonna go ahead, search this site. I'm gonna put in fiancé, Fiancee, fiancé. Let's just see what happens. Okay, I'm tired of messing around, right? Look at this. Wow, getting married in Russia, marriage in the Philippines. Okay, new non-immigrant 41.81K notes. Look, I mean, how am I going to find my fiancé visa information here? Look at this. All right. Well, fiancé visa. Let's see what happens on that. Or K-1, right? Well, let me see. That didn't really work out well either. So let's just get rid of this and let's just do K-1. Okay, we're going to search K-1. Now, look at that. All the results for K-1. So this exercise I'm showing you is to understand how different the language is from these sites, right? So non-immigrant visa for fiancé K-1. All right, let's go to this first hit here. Oh, look at this. This is the gold mine here. Now we're there. Non-immigrant visa for fiancé K-1. Look at all this information, right? So we're going to jump into this now. We're going to walk through this information. And we're going to take it step by step here and really get into this because this is going to answer and give you an incredible overview of this whole process. And then when we get into it, you're going to make so much more sense about what's happening. Okay, overview. What is a K-1 visa? All right. Fiancé K-1 non-immigrant visa is for the foreign citizen fiancé of a United States citizen. I'm going to bring this up a little bigger here. Foreign citizen will then apply for adjustment of status to a permanent resident, LPR. Oops, sorry, skip this. The K-1 visa permits the foreign citizen fiancé to travel to the United States and marry his or her U.S. citizen sponsor within 90 days of arrival. Great, we know that. Foreign citizen will then apply for adjustment of status to a permanent resident with the Department of Homeland Security's U.S. Citizenship and Immigration Services. Because a fiancé visa permits the holder to immigrate to the U.S. and marry a U.S. citizen shortly after arrival in the United States, the fiancé must meet some of the requirements of an immigrant visa. Okay, that's what I was saying. Some immigrant visa requirements. Eligible children of K-1 visa applicants receive K-2 visas. Great, so this is redundant. What is a fiancé? Okay, under U.S. immigration law, a foreign citizen fiancé of a U.S. citizen is a recipient of an approved petition for alien fiancé, Form I-129F, who has been issued a non-immigrant K-1 visa for travel to the United States in order to marry his or her U.S. citizen fiancé. All right, so That's pretty cut and dry. A fiancé is someone who has already been approved of as a fiancé by the U.S. Immigration Service and the embassy. Both the citizen and the K-1 visa applicant must have been legally free to marry at the time the petition was filed and must have remained so thereafter. The marriage must be legally possible according to the laws of the U.S. state in which the marriage will take place. Great. So it says here, interestingly, legally free to marry at the time the petition was filed. The petition. Okay. So don't file the petition, then get divorced, and then get get the old marriage dealt with. You have to have that done before you actually file the petition. Okay. In general, the foreign citizen fiancé and the U.S. citizen sponsor must have met in person within the past 2 years. USCIS may grant an exception to this requirement based on extreme hardship for the U.S. citizen sponsor to personally meet the foreign citizen fiancé, or, for example, if it is contrary to the U.S. citizen sponsor's or foreign citizen fiancé's culture for a man and women to meet before the marriage. Great. We've already been on through that with the USCIS. Now here's something we really haven't talked about yet on the overview from the USCIS, which is the International Marriage Broker Regulation Act of 2005. Okay, detailed information about the IMBRA requirements is contained in the Form I-129F, Petition for Alien Fiancé Instructions. Basically, Marriage Broker Regulation Act is that if you are paying a marriage broker to buy you a wife, they're not considering that to be necessarily a good faith fiancé marriage relationship. There's also the issues of trafficking, human trafficking, which is really serious, and many women are trafficked into the United States under fiancé visas and are subject to insane slavery and domestic violence issues once they come in. So we definitely do not want that to happen, and USCIS is fully committed to keeping that from happening now, which is great. So if you have used a marriage broker, there's some different questions they're going to ask you that you have to be prepared to show, that, yeah, I used a marriage broker, but this is still a real fiancé relationship. Furthermore, if you have been convicted and you're a petitioner for a fiancé and you've been convicted of domestic violence, you're going to have to show that the fiancé knows about it and that you're not going to be practicing your domestic violence habits on her. So big issues that are definitely going to need to be taken care of if those are in your situation. And if you have those situations, I think it might be better to talk to an attorney about those kinds of things, because those do open up some big doors. Now, I have definitely gotten those petitions approved, and it's very difficult. It took a lot of time, a lot of proof, a lot of legal stuff, but it's still totally doable. Okay, the first step, filing the petition. We've gone over that, right? And here's the thing. Note, Form I-129F cannot be filed at the U.S. Embassy, Consulate, or USCIS office abroad. That's true. We've already seen the USCIS website where they have the domain around that. After USCIS approves a petition, it is sent to the National Visa Center for processing, and the NVC will send it to the U.S. Embassy or Consulate, where your fiancé will apply for a K-1 non-immigrant visa. Perfect. And that's the thing. The National Visa Center, they're doing the heavy lifting for the embassies. Embassies don't want to have to deal with all this processing of all this paperwork and preliminary determination around whether or not this is a good fiancé relationship. So they've delegated these tasks to the National Visa Center. Okay, second step, applying for a visa. Once the U.S. Embassy or Consulate where you, the foreign citizen fiancé, will apply, receives the petition from the National Visa Center, it will provide you with specific instructions, including where to go for the required medical examination. Very important. During your interview, ink-free digital fingerprint scans will be taken. Some visa applicants require further administrative processing, and this is hyperlinked here, which will take additional time after the visa applicant's interview by a consular officer. That's true. Want to look at what administrative processing is? Let's see what they have to say about administrative processing. I know about administrative processing because I've had clients who go through administrative processing. And it's like the black hole. You will never know what, why, where, when, how. It is stuff. It ranges from sending people out to the little village where the fiance lives, asking about if they're really married, if they have any other husbands, to doing background checks, different kinds of banking checks to see if there's any kind of illegal financial transactions going on. All this different stuff is all under the guise of administrative processing. It says there, most administrative processing is resolved within 60 days of the visa interview. I wish that were true. In my experience, a lot of times they take a lot longer than that. So, but 60 days. I don't bug them before 60 days have gone by. Basically, that's so that's true. Eligible children of K-1 visa applicants may apply for K-2 visas. Separate applications must be submitted for each K visa applicant, and each K visa applicant must pay the visa application fee. So that's true, and you'll see when we go through the National Visa Center processing, they're going to separate the petition out, because when you go to the USCIS, you don't file a separate I-129F for a child. You just include them on the same I-129F. It's at the National Visa Center where the cases get broken apart into two separate cases. Required documentation. Yes, the foreign citizen fiancé and eligible children applying for K-2 visas will be required to bring the following forms and documents to the visa interview. So now we're really getting into some more detail about what they're looking at. You're going to bring 2 non-immigrant visa applications forms DS-156 prepared in duplicate. Note, K-1, K-2 visa applicants should not fill in the form DS-160 online non-immigrant visa application, right? So we're going to be going through this form here line by line, step by step. Make sure you know how to do that. 1 non-immigrant fiancé visa application form DS-156K, all right. 1 application for immigrant visa and alien registration form DS-230, Part 1. You're not required to complete Part 2, right? So you're starting to get some idea about why I like to print this stuff out. You got a checklist right here, right? You're going to want to be working this checklist. K visa applicants applying at U.S. Consulate General Montreal and U.S. Consulate General Ciudad Juarez have different application form requirements. Review information on the U.S. Consulate General Montreal or U.S. Consulate General Ciudad Juarez website to learn which forms you must complete. So again, come to this website, understand that there are exceptions to these rules, and get the most updated information. So our test case here that we're going to do, we have a sample, is actually we're going to use Montreal, because Montreal and Ciudad Juarez have special forms, electronic forms. We want to make sure you know how to work those. The other forms are pretty easy to go through, where you print them out and you actually bring them to the interview. But these guys, you have to actually submit them online. You have to scan documents, all sorts of different stuff. So we're going to use the more difficult case processing of Montreal as an example on this tutorial. A passport valid for travel to the United States and with a validity date of at least 6 months beyond your intended period of stay in the U.S. unless country-specific agreements provide exemptions. Well, here's a hyperlink to country-specific exceptions. Countries that extend passport validity for an additional 6 months after expiration. Okay, so there you go. These countries here, there are exceptions to that, so you're probably going to be okay if you have one that has less than 6 months on one of those countries. Divorce or death certificate of any previous spouse for both you and the U.S. citizen sponsor. Police certificate from your present country of residence in all countries where you have lived for 6 months or more since age 16. Police certificates are also required for accompanying children age 16 or older. Okay, that's a big deal. I mean, this can be a big deal if you've moved around a lot, right? Medical examination. Vaccinations are optional, see below, because this is a fiancé visa is actually the non-immigrant. This is the part that's like the non-immigrant visa part where the vaccinations are optional. Evidence of financial support. Now this is a Form I-134 affidavit of support may be requested. So I definitely like to have my I-134s done before I go in, because if they request them, you've got them, and they're not that difficult to put together. We're going to go over how to prepare Form I-134. Two by two photographs. See the required photo format explained in photograph requirements. We're going to go through that. Evidence of relationship with a U.S. citizen fiancé. So this is going to be your stack of photos, all of your phone, all of your emails, all of your letters from friends and family explaining what a great fiancé relationship you guys have. All right. Payment of fees is explained below. So you probably go pay your fees somewhere, and then they give you a receipt that you've paid your fees. You bring that into the interview with you. Note, the consular officer may ask for additional information, such as photographs and other proof that the relationship with the U.S. citizen fiancé is genuine. Documents in foreign language, other than the language of the country in which the application takes place, should be translated. It's true. Applicants should take to the visa interview clear, legible photocopies of civil documents and translations, such as birth and divorce certificates. Original documents and translations will be returned. So you're going to be bringing your original and a copy. And so if they want a copy to save in the file, they'll take the copy. The original, they'll return to you after they inspect it to make sure that it is a valid original. So then we're going into the medical examination and vaccination requirements. In preparing for the interview, applicants will need to schedule and complete a medical examination. Before the issuance of an immigrant or K visa, every applicant, regardless of age, must undergo a medical examination which must be performed by an authorized panel physician. You'll be provided instructions regarding medical examinations from the U.S. Embassy or consulate where you will apply for your visa, including information on authorized panel physicians. So that's true. So as we go forward then, we're going to look at the actual embassy requirements for all of these things, because each embassy may have a little bit different requirement for what they want, and I will definitely show you how to do that. K-visa applicants are encouraged to get the vaccinations required under U.S. immigration law for immigrant visa applicants. Although such vaccinations are not required for visa issuance, K-visa issuance, they will be required when adjusting status to that of legal permanent resident following your marriage. Applicants are therefore encouraged to fulfill these vaccination requirements at the time of the medical examination. See vaccination requirements for IV, which is immigrant visa applicants, for the list of required vaccinations and additional information. So yeah, I mean, we're going to go into this also, but this is the list of the stuff that you need the vaccinations for, and it is true, when you come in on a fiancé visa, you're going to have to go and get a full-blown medical exam. Now, if you've already done your vaccinations and you have a card saying that you've already done your vaccinations, you don't have to do them over again. So if you do get the vaccinations, make sure you save your card and you submit that with your adjustment of status application when you come into the United States, get married, and go for your green card. Proof of financial support and affidavit of support forms. During the visa interview, applicants will be required to present evidence to the consular officer that they will not become a public charge in the U.S. You may present evidence that you are able to financially support yourself, or that your U.S. citizen fiancé is able to provide support. The consular officer may request that a Form I-134 affidavit of support be submitted by the U.S. citizen fiancé. The U.S. citizen fiancé will need to submit Form I-864 to the USCIS with the application for adjustment of status to that of legal permanent resident following the marriage. So what they're saying is, right now, we will allow a lot more wide range of proof that you actually will not become what they call a public charge, dependent on the United States for welfare, food stamps, that kind of thing. And they are able to show, present evidence that you are able to financially support yourself. So if you're working in your foreign country as the fiancé, then your employment history, your employment verification letter, your pay stubs, all that stuff can be presented at the embassy to show that you earn enough money if your sponsor does not earn enough, or is unemployed, or is having problems, which is great. Now, A consular officer, again, we're going to go through the I-134 because we know consular officers love I-134s. So we would prefer that you fill out an I-134 and have it ready to go at the embassy. Do the same income requirements apply to Form I-134 as apply to Form I-864? No. Bill 125% of the federal poverty guideline minimum income requirement, the most recent year's tax return, and other requirements only apply when Form I-864 is needed. Applicants presenting Form I-134 will need to show that their U.S. sponsor's income is 100% of the federal poverty guideline. So there we give you, again, a little bit of leeway there. But I like to set these I-134s up with a lot of evidence, and if you're only making 100%, it's why not get another person to sponsor or put together another I-134 just to put you over the hump, just to get you past the scrutiny, because this is your one shot, you know. And I would recommend then, if you're close to the 100% of the poverty, you're at the poverty line, and you're bringing in a fiance, they're going to be going, what, you know. Go over the top. Say, yeah, I'm having some hard time now, but look, I got another joint sponsor. Between the two of us, we're going to make sure that if she gets hurt, she'll be taken care of. She won't need to go on welfare. She won't need to go on food stamps. And you'll notice I'm using the word she to describe the fiance. That's because our test case is a male U.S. citizen sponsoring for a female fiance to come into the United States. So I'm just using the word she now to just make it consistent with all the documents, all the photos, all the birth certificates, everything that we actually have. Fees, how much does a UK visa cost? Well, that's a good question. Fees are charged for the following services: filing an alien fiancé petition, Form I-129F, non-immigrant visa application processing fee, Form DS-156, medical exam. Other costs may include translation and photocopying charge, fees for getting the documents required for the visa application, such as a passport, police certificates, birth certificates, and travel expenses to the U.S. Embassy or consulate for an interview. Costs vary from country to country and case to case, right? So for looking at the fees, when we're doing the forms, we'll show you what the fees are, but you know, definitely you're going to want to know what the fees are, because you got to pay those fees. And it comes out to be, it's usually like around $600, $700, something like that. Rights and protections pamphlet. Okay, now this is an interesting thing. You should read the rights and protections pamphlet before your visa interview to learn about your rights in the United States relating to domestic violence, sexual assault, and child abuse, and protection available to you. The consular officer will verbally summarize the pamphlet to you during your interview. Additionally, K-1 visa applicants will be provided with any existing criminal background information on their U.S. citizen fiancés that the USCIS received from other government agencies during processing of their Form I-129F petitions. This is a huge deal. I mean, thank goodness that we have these safeguards in there to protect fiancés coming in from being trafficked and being victims of sexual abuse and domestic violence. And that's how they do it. My petition expired can be extended. The I-129F petition is valid for 4 months from the date of approval by the USCIS. A consular officer can extend the validity of the petition if it expires before visa processing is completed. And that's true, because remember I said it takes about 9 months, right? Well, your I-129F petition is going to have an approval notice, and it's going to have 4 months on it. And that's usually not enough time to get the case all the way through the National Visa Center and then get to the embassy and then get all the stuff done. It usually takes more than 4 months to do that, or right around that amount of time. So if it expires, people, listen up. If your I-129F approval notice is expired before you go to the embassy, don't worry about it. Okay, don't worry about it. They will renew it. They will consider it to still be valid. They're not going to kick you out and make you go all the way back to the beginning of the line because there's been delay that you haven't caused. Well, even if you have caused it a little bit, it's still going to be okay. So don't panic if your date is not current when you're going into your visa interview. Okay. Let's see. Ineligibilities for visas. Oh my goodness. What if I am ineligible for a K visa? Certain conditions and activities may make you, the applicant, ineligible for a visa. And that's really true. Examples of these ineligibilities include drug trafficking, overstaying a previous visa, and submitting fraudulent documents. If you are ineligible for a visa, you'll be informed by the consular officer and advised whether there is a waiver of the ineligibility and what the waiver process is. Learn more and see the complete list of ineligibilities. Well, hey, let's look a little bit at this. Ineligibilities. What, you know, these questionnaires have all the questions around the ineligibilities. They ask you, have you ever dealt drugs? Have you ever procured a prostitute? Have you ever committed an act of terrorism? So they're really specific about the ineligibilities. So here is the this issue about ineligibilities. I'm not going to go so much into it, about it, but certainly it's something to understand. Here's the visa ineligibilities are listed in the law that talks about it. So here's 214B visa ineligibilities. Every alien other than a non-immigrant described in paragraph L or V of section 101A15 and other than a non-immigrant described in any provision of section 101A15H, except subclause B1 of such section, shall be presumed to be an immigrant until he establishes to the satisfaction of the consular officer at the time of application for a visa that the immigration officers at the time of application for admission, I'm reading that twice and I'm sorry, that he is entitled to a non-immigrant status under section 101A15. And so what that means is that one of the grounds of ineligibility for a non-immigrant coming in is that you actually are an immigrant, meaning you want to come and stay and live and party and get a permanent residence here in the United States. Well, hold on a second. You're coming in as a non-immigrant tourist, right? You want to come and get married and live as a green card? That does not work. You got to file for the right visa category. So this is a type of ineligibility that might happen under the law. They're giving you a 214B ineligibility thing. And so they got the 221G, the 212A, different categories of ineligibility. And then they talk about the waiver, okay? And so, immigration law really is compassionate in a lot of ways. They will allow you, even if you've done something bad, a waiver of that, which means they are going to allow a pardon for you. Even though you've done something wrong and you're bad, they'll still give you a pardon. And so the waivers of ineligibility are based on family relationships and different types of events that actually happen. So here's, for instance, a 212D waiver for a non-immigrant. Okay, so if you're coming in as a tourist, they want to hit you with this ineligibility. You know what? You can still apply for a 212D waiver. And the 212D waiver may waive the application of subsection A other than paragraph 3E in the case of a non-immigrant described in section 101A15S if the Attorney General considers it to be in the national interest to do so. Okay. So that's pretty wide. You would say, you know what, it really is in the national interest to let me in. And they decide whether or not they want to let you in or not. Okay. So this is the nuances then of visa ineligibility and waivers around that for a K visa. How long will it take to get my K visa? Okay, so the website for the status, you can check out the status of your application. We'll show that more. And then there's different types of processing times along that as well. After you receive your K-1 Fiancée visa, this is interesting. If you are issued a K-1 visa, the consular officer will give you your passport containing the K-1 visa in a sealed packet containing the civil documents you provided, plus other documents prepared by the U.S. Embassy or consulate. It is important that you do not open the sealed packet. Can you? Oh, man, don't do it. Don't do it. It's like, so, oh my God, what's inside of this thing? Help me. Don't do it. Leave it sealed. Don't look in there. Only the DHS immigration official should open this packet when you enter the United States. As the K-1 visa holder, you must enter the U.S. either before or at the same time as any qualifying children holding K-2 visas. So that means you're going to come in with your kids. With your visa, you can apply for a single admission at a U.S. port of entry within the validity of the visa, which will be a maximum of 6 months from the date of issuance. So what they're saying is that, okay, I go to the embassy, I go through everything, get my medical, get all my documents, I go up, they give me the visa. Yay, I get it in the mail. Okay, I got it. I got the sealed packet too. Wow, okay. I still have 6 months to enter. It might take me a while to get all my fares arranged, to get everything taken care of before I leave. So that's going to have a 6-month window for me to actually enter the United States. And then after you enter, again, you must marry your U.S. citizen fiancé within 90 days of your entry into the United States. That is a hard rule there. Does my U.S. citizen fiancé need to file separate petitions for my children? I covered this. No, you just apply for one. After your marriage, your children will need to file separately from you for adjustment of status. Every person files their own green card application after they come in. And important notice, under U.S. immigration law, a child must be unmarried. In order to file for adjustment of status for a child following your marriage to a U.S. citizen spouse, the child-stepchild relationship with your spouse must be created before the child reaches the age of 18. This is an important notice. So if you come in as a fiancé and they are a child of, they're 18 years old, okay, they're a child for purposes of a fiancé visa. Great, but they're not a child for purposes of getting a green card. So, because the stepchild relationship is going to be starting after the child reaches the age of 18, right? So, step-fiancé relationship's one thing, but stepchild relationship is something else. So, bottom line, you're going to want to get all this stuff done before your child turns 18. Make it easy. Are my children required to travel with me? Your children may travel with, accompany you to the United States, or travel, follow to join. Like you, your children must travel within the validity of their K-2 visas. Separate petitions are not required if the children accompany or follow to join you within 1 year from the date of issuance of your K-1 visa. If they want to travel later than 1 year from the date your K-1 visa was issued, now again, they're not talking about the old application from the USCIS. They're talking about the visa that's in the passport issued by the embassy, okay? If they want to travel later than 1 year from the date your K-1 visa was issued, they will not be eligible to receive K-2 visas, and separate immigrant visa petitions will be required. If your child has a valid K-2 visa and you have already adjusted status that of a permanent resident, your child may still travel on the K-2 visa. So this is interesting, accompanying and travel after, because sometimes the kids can't come with the fiancé, and the fiancé goes ahead and gets married and all that stuff, and they want to double back and bring the child in. That's okay, as long as it's within a certain time frame. Entering the United States port of entry, a visa allows a foreign citizen to travel to the U.S. port of entry and request permission to enter the United States. You should be aware that a visa does not guarantee entry into the United States. Boy, is that true. The Department of Homeland Security, U.S. Customs and Border Protection, CBP officials have authority to permit or deny admission to the United States. Upon arrival at the port of entry, be prepared to present to the CBP officer your passport with visa and your unopened, sealed packet containing your documents. Unopened, right? Don't open it. Sealed. Travelers should review important information about admissions and entry requirements on the CBP website under travel. And let's face it, as an immigration attorney, I say, okay, we're going to go ahead and prepare this stuff for you. We get the petition approved. They go to the embassy. They get the embassy approved. They're coming across the border, and they make some remark. They make a statement like, this guy is I don't know if I'll be getting married to him or not. We'll see. We've been fighting on the plane or whatever. Uh-oh. Guess what? You have to have the intent to marry, and now you've made a statement that you do not intend to get married at the border. They can deny your entry right there. deny your entry, kill your whole case right there at the border. So when you're making the entry across the border, then it's very, very important that you don't make any statements or act any way or have any evidence that you're going to be doing anything other than getting married within 90 days after your entry. Okay? So really good idea to talk about the wedding plans when you're coming in across the border. All right? Adjustment of status, working in the United States and traveling outside of the United States. Okay, so we've gone through that. How to apply for Social Security card. Okay, you can apply for Social Security, no big deal. Further questions. Okay, great. So I think this pretty much concludes the overview. We've gone into really good minutia around what is actually going to be happening. And so our next thing we're going to do is we are going to start going into the forms, right? And looking at the forms and actually going into the documents that you need, because the next thing we're going to do is we're going to get together all of the documents and all of the forms that you need to start your processing with the USCIS.